So welcome. As a quick introduction for those of you I don't know, my name is Matt Kaufman. I'm an attorney based out of Cheyenne with the firm of Hathaway Kunz. I'm also a partner with a small crypto hedge fund based out of Denver called DAO Capital. And just kind of a quick entree into how I got involved in all of this. I was a two-time appointee by the governor to what was originally called the Wyoming Blockchain Task Force. It has been since turned into a permanent committee called the Select Committee on Blockchain, FinTech and Innovation. And then I'm also an appointee to the Wyoming Supreme Court Chancery Court Committee. For those of you that don't know, and since we're all lawyers, Wyoming has instituted a brand new Chancery Court that's going to go live in about 70 days. And so we're pretty excited about that. And then, it often gets thrown around that Wyoming has passed 20 or 24 pieces of legislation. I've been privileged to co-author a few of those and work in some way, shape, or form on pretty much all of them. So I've been a part of this effort from the beginning. So to kick it off with DAOs. So what problem was Wyoming trying to solve? And probably everyone in here generally knows what a DAO is to begin with. It stands for Decentralized Autonomous Organization. My definition of kind of what a DAO is probably different than some of the technologists' definition, but my definition is that it's a community participation group that aims to collaboratively, whether it's collaborative effort, collaborative capital, launch a project and execute a project. This gets really tricky as we try to put that box right on these evolving projects that are out there in the technology community. And we're going to talk a little bit about that transition of what it looks like, at least in Wyoming's mind, to take one of these community organizations and put a formal structure to it. It's obviously not clean, it's messy, but we're trying to work through it here in Wyoming. Historically, a lot of the DAOs that have traditionally been used, many of them were foundations or organized as foundations. A lot of them were just operating as unincorporated associations. There have been some LLCs. Vermont has often been talked about as a domicile for these LLCs, even New York, lots of places. But for the most part, a lot of these DAOs don't have a formal traditional entity structure. And so the problem that creates is you default to a general partnership. And in a general partnership, right, everybody's got unlimited liability. And so that's really the problem that I would say that we were first trying to tackle with this Wyoming DAO LLC is solving that problem of unlimited liability. And I didn't mention this, but obviously stop me at any time, guys, if you have questions or you want to dig deeper on something. So I went through this a little bit ago in the last presentation I gave, but I think it's really important to understand kind of what Wyoming did, the context of Wyoming statute. So most of you probably know that under Wyoming's LLC Act, and for those of you that don't know, you should know Wyoming was the state that invented the LLC to begin with, but we have two predominant types of LLCs. There's manager-managed LLCs and member-managed LLCs. The default in the statute, if you don't make an election otherwise, is that you're a member-managed LLC. The statute provides there's a couple different ways that you can become manager-managed, either in your articles or your operating agreement or some other management style document. You have to affirmatively make that election. This is important as we go on in the conversation because DAOs are authorized to only be member managed. There cannot be a manager managed DAO. So that's a very important default rule to understand in terms of how we organize that structure. I reference in here that there's a few other subtypes of LLCs under our statute, close LLCs, L3Cs, which I'll expose my bias, and I've never used one, and I would never recommend it to a client for any reason. But anyways, those do exist. And what's important that I note about particularly the close LLC is that it was built as a supplement to the LLC Act. Wyoming's LLC Act, again, from a lawyer's perspective, is kind of sacred, right? We really don't want to mess with the underlying default rules of the Act. So this was designed to be a supplement, much like the Close LLC Act is designed as a supplement. And with that, we get into sort of the application of the underlying LLC Act. And so it's important to understand that the LLC Act itself still applies, right, as default rules insofar as you're talking about a member-managed LLC, to DAOs. But where the DAO LLC Act has specified explicit new rules and alterations of those default rules, now we have to go look at the rules of the DAO LLC Act. But otherwise, the chapter doesn't repeal or modify any statute or rule of law. The underlying LLC Act is still what remains. So now we're going to get into sort of the meat of this. And I think it's really important for anybody that's wading into this area to kind of understand and think a little bit about the definitions that are baked into the LLC Act. And a lot of these definitions don't appear anywhere in the LLC Act or in the DAO LLC Act. So first of all, it's important to understand that Wyoming's done a lot of work in defining a lot of these terms already. So blockchain is defined in the Wyoming statutes in the Digital Asset Act. Digital asset is defined. Digital asset more specifically is broken out into 3 different types of digital assets. Wyoming has said there's virtual currency, right? There's digital securities, and then there's essentially digital consumer assets, which is kind of everything else. Wyoming has, and I'm sure many of you, if you follow what Wyoming has done, one of the first acts that Wyoming took in its sort of block of legislation that it's passed after it fixed the Money Transmitter Act was the utility token exemption. And in Wyoming's utility token exemption, essentially what it did was define what a utility or consumer token is. And to address the securities problem that a lot of companies were having in terms of issuing tokens, define that if you are truly issuing a token that falls within that consumptive or utility purpose, then Wyoming's not going to define you as a security. So interestingly, there's a couple different ways that utility token or that consumer token, as I like to call it, can get wrapped up into that definition of a digital consumer token, but it does happen, and they're in many cases used synonymously. The majority of the members under the current Act language means approval of more than 50% of the participating membership interest in a vote for which a quorum of members is participating. I call this one out specifically, and I said I was joking that I was going to call on many of you, and I am, because I got to call him out. Mr. David Hopkinson is sitting up in the corner. He's the LSO legislative attorney, staff attorney, who has helped us write and craft all this legislation. And I'm very candid with people when I talk about this act, even though I'm really proud of what Wyoming has done. I am under no illusion that we got it perfect on the first try. This is a quickly evolving area of law. This is, definitely a square peg in a round hole problem we're trying to solve. And some of this stuff, honestly, we tried to fix it last year before the act was even passed. We just ran out of time. And this was one of those definitions that we were working on changing even last year. The reason being is that requiring of a DAO to have more than 50% of the participating membership interest vote to establish that quorum might be a problem, candidly, for a lot of them. In fact, he just stepped out, but one of my law partners and I have been working on this in DAO operating agreements and working with shifting the paradigm of what is a quorum. And that's something that I think is really fascinating from a lawyer's perspective in terms of, we've all drafted operating agreements for an LLC, and you establish what it means to determine a majority of the members or a quorum. Well, I'll just share with you something that we're playing with. What if the quorum paradigm is not defined on who participates, it's defined on when they participate, right? So for example, a lot of DAOs already in their voting protocol might push out some sort of a proposal and give members 48 hours to vote, right? So what we're looking at doing is how do we take these default LLC rules as an example and define quorum by whoever votes in the next 48 hours, that's the quorum, right? So we're trying to flip that incentive, right? No longer do you give the power of non-participants, right? That ability to weigh down or drag or slow the decision-making of the entity. We're trying to incentivize active participation. And that brings with it all kinds of legal questions and challenges. But I use that as a case in point because it became apparent to me pretty quickly, even as we were passing this act, that a lot of the active DAOs we were talking to were saying, that 50% threshold is going to be a big problem for a lot of DAOs. So we've got to have flexibility in the act to change that. So anyways, I called this one out because, David, we have language queued up, right, to change this, to fundamentally change this definition. So as I go through this today, I felt like it was really important to call out to everyone that there actively is an amendment already to the DAO bill that has been tentatively passed by the committee. It'll be up for final committee approval in November, and then hopefully will be before the legislature this next year. But some of these definitions are already going to change. So, yes, sir.
Would it be possible under the law or even the new amendment for a DAO to do scaled voting so that maybe people with huge interests don't just capture the DAO and get to set policy? So you could.
Yes, the short answer is absolutely. I think that the LLC Act needs flexibility to define, again, think of it as we're dealing with the default rules, and those default rules can be changed by agreement. And so I think the short answer to that is yes. So the next definition I want to talk about was membership interest. And that obviously means a member's ownership share in the member managed DAO, which can be defined in the entity's articles, smart contract, or operating agreement. The membership interest may also be characterized as either a digital security or a digital consumer asset defined in the statute. This is a particularly important one. We had a very academic discussion with a number of professors as we were going through this process, because it was brought to my attention, and I think I was just thinking about this too narrowly, but the DAO Act might be one of the first places where it gives the members the ability to define, because Wyoming has already created these 3 different asset categories for digital assets. The DAO gives the members an opportunity to make an election as to which type of those digital assets they want to be. Now, that doesn't mean the SEC or the IRS is going to respect that election, but it at least gives the members an opportunity to say, no, we're a governance token, right? We are a digital security. We are something else, and specify in the formation documents for that articles and tie rights to that membership interest that correlate with what category they are. The next definition here is open blockchain. Again, Wyoming has taken great lengths to sort of define what blockchain means. The quorum definition, I touched on this already. I think we quickly figured out we have a little bit of a circular definition if you really pay close attention to the current DAO Act in terms of defining what a quorum is and then what a majority of the members means. And so again, with the new revisions, I'm pretty confident we're going to fix that. And I think that that'll be a great improvement to the current act. And then lastly, the idea of a smart contract. So sometimes, again, I'm not a technologist, I'm a lawyer, but we've had some of the technologists say, why do you call it a smart contract? It could be something different, right? Maybe it's just software. Maybe we want to call it an algorithm. Maybe we want to call it a protocol, whatever. We're working for this purpose off of Wyoming's definition of what a smart contract is. So unless and until that definition is modified by the legislature, that's the confines we're working in. So now I'm going to get into some of the legal considerations and aspects regarding formation of the DAO. So, and I shared this previously with the other group, and I think it's important for people to understand, particularly practitioners, but if you're familiar at all with Wyoming LLCs, you can appreciate that one of the most, I think, attractive features of Wyoming LLCs for a lot of people is the privacy orientation of Wyoming's Act, and the fact that our Secretary of State just doesn't require, let me finish my thought and I'll come back to you, doesn't require the disclosure of very much information. The DAO LLC kind of shifts that paradigm just a little bit. The policy of the legislature, at least in my view, was more towards, hey, this is a really experimental and new and unknown entity type. We're going to gravitate towards a default policy of disclosure and transparency. And so with the articles, there are some definite requirements, and we'll go through these in a moment, that you don't see for traditional LLCs. And it's been interesting from my perspective, because just in the first 50 or so DAOs that have been filed in Wyoming, we're already seeing people push the bounds of what our Secretary of State is comfortable with. And so I think we're going to see some pushback on this in the next iteration of the DAO bill. But I think it's important, and I'll go through the specifics in a minute, but to understand it is a little bit of a paradigm shift away from the privacy-driven orientation of the traditional LLC. You had a question, sir.
Why am I considering the Corporate Transparency Act in this legislation? And is that a deal breaker for people who are coming to Wyoming for purposes of privacy?
So I'm not aware, and somebody else in here might be, but I'm not aware of any discussion of a Corporate Transparency Act in terms of a deal breaker. I mean, I can only speak for my clients and most of the people that we work with. I mean, candidly, they love the privacy aspect that the Wyoming LLC provides. I think the policy discussions I've been a part of acknowledge there's a downside to that, Panama Papers or whatever you want to call it, but at least for the most part, the pros outweigh the cons. And so I haven't heard much discussion beyond that. Yeah.
I'd say with the Panama Papers, we did have a house in downtown Cheyenne that had like 8,000, LLCs in it, and that's sort of the abusers. And that's a previous secretary's statement. They did very small nips and tucks and stayed with the privacy policy.
Yeah.
Even when the bad thing happened, they stayed.
Right. Yeah. So diving back into some of the filing requirements for the DAO, this to me is one of the big ones. You are required under our current act that you have to have appearing conspicuously on the articles of organization a notice regarding the restrictions on duties and transfers. And so that block of language I have right in the middle is actually required language. It has to clearly and unequivocally confer to the potential members that the rights of members of a DAO might, materially differ from that of a traditional LLC. And that, again, the onus is on the individual member to understand what that means. And because we're putting the onus on the individual member to understand what that means, that goes hand in hand with one of the other requirements that we'll talk about in a minute of the DAO. And that is there has to be a publicly available identifier for the protocol, smart contract, right? Whatever it is, software that is going to automate the DAO. And again, that was a policy decision on the part of the state of Wyoming. I'll leave it to you all, and time will tell if that was the right policy decision or not. But the again, placing the burden on the individual to understand what that smart contract says, what that smart contract means, how it operates. In the mind of, I think, the Wyoming legislature, the only fair thing to do then was to require entities to be forthcoming with the identity of that smart contract. There was another question.
So typical LLCs can obviously also have rights that vary from the statutory rights, right? So why was it? What was why do you think the choice was made to require this disclaimer in the context of a DAO specifically, where it's not required in the context of a traditional LLC, which has the same issue?
Yeah, I think, and I'm going to get into this more a little bit later, but at least in my view, Wyoming is one of the first places in the corporate context to take a swing at creating a legal hierarchy that includes the articles, right? The governing documents like an operating agreement and the code. And in this particular context, as we'll go through in a little bit, the code is actually the predominant, right, body of written work that governs the entity. And so if that's going to be the case, I think the state acknowledged and understood that there has to be a heightened disclosure requirement. And this is part of that, right? This is a way to disclose to those members that this entity is different. The rights and the duties of the members are going to be different. The legal obligations are going to be different. And so it's an effort to be transparent and call for disclosure. Maybe that's right, maybe that's not, but that was the policy decision. Yes, sir.
So a lot of DAOs can be used for public goods. Has there been any conversation about forming a nonprofit entity but also have the same kind of?
Yeah. Nobody started on the topic. So,
sorry.
Real quick, Wyoming is one of the few states that doesn't have a public benefit corporation strategy. We actually tried to get it passed last year. But that was actually a conversation. Could you have a public benefit style DAO that might have the ability to vary the director's duties, right? So you get outside of kind of the Revlon doctrine style of, the director's fundamental duty is to maximize return for shareholders. Could you have something akin to that in the DAO LLC context where maybe the duty of the director could be community driven, right? Or public benefit driven. We didn't make it that far. And I suspect that conversation's not dead because you're right. A lot of DAOs are community driven but that also invokes some different tax implications as well. And I don't think anybody knows really how to tax a DAO right now, let alone tax, what claims to be a nonprofit DAO or something like that. So moving on in the requirements of the articles, obviously there's requirements with respect to the name. I just thought it was worth calling out that DAO LLCs in Wyoming have to include DAO, LAO, DAO LLC, some combination thereof in the name. We got a lot of pushback, amazingly, on that because a lot of people hate that and they think it's cumbersome, but it fits with the legal naming convention of the state now, and so that's what it is. Again, the articles cannot designate that the DAO LLC is manager managed. And one of my law partners who's sitting up there in the back, we were actually debating this on the way over, but we were thinking to ourselves, what would happen in the event that a DAO made the election in their operating agreement or in their smart contract to delegate management to a manager or to delegate some subset of people as managers? I don't know the answer to that. Someone's going to do it and it's going to be a mess. But right now, at least under the Wyoming statutory framework, it has to be member managed. And so I think DAOs are going to have to sort through and work through what that means, right? In terms of being a member and how do you meaningfully participate in the management of the company as a member? Because as that right gets diminished, that's going to change. And I keep saying I'm going to call on people. I'm going to call out these two gentlemen right here who formed the very first DAO in the state of Wyoming, and their DAO. I did file it. Yeah. Their DAO is going to be predominantly oriented for governance purposes, right? And the token that will be distributable through the DAO is going to be a governance token. But that, again, calls in some interesting questions from a member's perspective of if we start stripping away, right, the fundamental rights that come with membership in an LLC, right? Information rights, rights of distribution, rights of participation. By design, right? We're stripping away some of that. What's the limit? How far can we take that elimination of rights? And I don't pretend to have that answer, but we're going to find out.
Sorry.
Yeah.
Do you mind just going a bit more detail as to why this was done? Was it done to protect the members so they cannot be? Was that the intention behind this clause?
In terms of the manager management?
Yeah.
So that really gets back to my first comments in terms of the underlying structure of the LLC. Yeah. And that we have only two predominant forms. We either have member managed or manager managed. And so the decision was made that these have to be member managed in order to fit. Well, for a couple of reasons. One, it requires the active participation of the membership at whole. What I was just saying is how far that active participation can be stripped down and how far you can remove those rights. I don't know what the limits of that are. But the second you delegate the active management to a manager, it fundamentally changes the fiduciary duties. It fundamentally changes the inter-member duties and obligations. And again, the default of the Wyoming statutes is predicated on a member managed structure. So unable to fully invoke all of those default rules, it has to be member managed. Yeah. So a little bit more discussion about some of the issues regarding formation of a DAO. So any person can form a DAO. You have to have one or more members. And I put in some of the other formal requirements there. Each decentralized autonomous organization shall and continuously maintain a registered agent. Everyone, I'm sure, here is familiar with the concept of a registered agent. That's an in-state designated person or entity that is your source of service and your source of state filed contact with the Secretary of State. What I think the DAO has highlighted, though, for a lot of people is the interesting relationships that a company might have with a registered agent. For most practitioners like myself, we sometimes kind of roll our eyes at registered agent companies and, mass forming of entities and the lack of registered agents sometimes to have a real connection with those entities and fulfill those statutory duties. I think we have a lot of unanswered questions, quite frankly, with respect to what a registered agent's liability and duty is going to be in the DAO context. Because you now, for the first time, conceivably have a fully distributed, maybe even to some extent autonomous entity whose only single point of contact with the state of Wyoming is going to be this registered agent. That's a high burden on that registered agent, at least in my view. That's going to be a high burden for record keeping. That's going to be a high burden for interaction. It's going to be a high burden to know. We're going to talk in a little bit about some of the requirements of the DAO LLC Act of when a DAO has to dissolve by law. And those conversations have brought about who's that duty going to fall on to know if any of those events are triggered. Well, it might be the registered agent. And again, I'm not pretending to have all the answers or know if the Wyoming Registered Agent Act has in it what it needs to fully accommodate these disputes. But I call that question out because I think it's unanswered. Another issue that's come up a lot is that the decentralized autonomous organization may form and operate only for lawful purposes. And I think this is really interesting, regardless of whether or not for profit, right? That's unique language for an entity of this type. Does this indicate that we allow nonprofit DAOs? Not necessarily, because again, I mentioned before, I wouldn't begin to pretend that the IRS or anybody else would know what to do with that. But the decision was made by the legislature. And I think a lot of this came from the feedback regarding the community orientation of these DAOs, right? The community benefit, the community goal of these entities. That does it have to be for profit? It also gets at, again, for those of you that study business corporations, remember the definition of a general partnership, right? 2 or more people engaged in some enterprise for profit. Again, we're trying to opt out of that default rule to the extent we can. So again, I think this just, I meant to point this out to kind of raise some issues more than I did answer the question, because I don't know, but I think that's fascinating. I put a note to myself in here that the low profit aspect, we spend a lot of time in our firm talking about the DAO in the context of a securities analysis. And probably one of the most common questions I get asked is, so if we have a DAO and we're member managed, are we no longer a security? And I would not say that is true. Maybe, right? That could be true. And people are absolutely setting up DAOs with an orientation. And maybe I'll back up for a second. For those of you that aren't familiar with securities definitions, you've probably heard of the Howey test that everybody talks about in terms of how we define an investment contract and what falls within the definition of a security in the United States. Well, one of the elements of the Howey test is relying on the efforts of others, right? And so when you talk about the efforts of others, a lot of lawyers, myself included, would suggest that where you have an enterprise, let's say all of us over here, we form an entity and we are all equally contributing goods, services, effort, right? We're probably not dealing in securities amongst each other, right? Because we're all actively participating. We're not relying on the efforts of others. If you and I form an entity and we offer all of these people to invest money based on what you and I do, well, now you all are relying on the effort of us, right? That starts to get more at the heart of the Howey test. And so again, that conversation comes up a lot in the DAO is what is the effort of others in the context of a DAO? Is me being a member and just exercising a click of a button vote? Is that active participation? I don't know the answer to that. Maybe, maybe not. But if that's the only way the entity exercises any activity, right, is if collectively hundreds or thousands of people make those decisions, and that's all the input anybody has because everything else is executed automatically through smart contract protocols, well, it starts to look pretty compelling, right? That maybe that's not a security. So the last bullet point I have on here is something that I take full blame for in the original draft of the DAO LLC Act. So we had some language. What we were really trying to get at in the original draft was we were trying to ask people in the articles to express and put people on notice to what extent you're going to be algorithmically managed, right? Because there's a full recognition that some DAOs are going to seek to fully automate if they can. Some DAOs are not, right? Some DAOs might only have certain aspects. I'll give you a case in point. One of the DAOs that we've had the opportunity to work with and kind of see their inner workings. As a corporate attorney, it is brilliant because it's, in my opinion, the way that all entities should work. But what they have done is taken their operating agreement. They have pulled out every aspect of the operating agreement that requires a member vote. And they've just simply executed a smart contract protocol on a common web domain for the DAO. So anytime someone wants the company to take action, you go on the website, you submit a proposed action. Every member gets immediately notified under their operating agreement. Under their operating agreement, there's a 48-hour window for voting. Everyone gets an email notification, you vote, right? After 48 hours, the window is closed. Whatever action was voted on is automatically executed. In this case, it's an Ethereum-based smart contract protocol, and they trade in Ethereum or ERC assets. But it's so fascinating to me because it's all self-executing. It's perfect corporate governance. It maintains a record, and it's really neat. So anyways, let me get to your question one second. When we were drafting the language for the DAO Act, what we were contemplating was we understand there's going to be a spectrum of these DAOs in terms of all the way from just partially automated to fully automated. What we wanted for people to do was make an expression in the articles to let people know to what extent they're going to be algorithmically managed. Instead, if you read the verbiage, it makes it sound like we have either algorithmically managed or member managed LLCs. That was not the intent. And I think we're going to fix that with the amendment and make that much more clear that we're just asking people to sort of, as best as they can, disclose to future members where they fall on that spectrum or what their intent is to fall. You had a question.
I was just thinking that that's one of the ways we're talking about that quorum amount, and that's a time specific quorum amount, right?
Absolutely.
And so it enables those who are passionate about the issue to actually exercise the vote.
Right.
Those that didn't really matter, then pass on.
Right. Yep. Absolutely. Here's kind of just I won't go through this slide in detail, but some more formation issues. So again, I already mentioned this first point, but DAOs are required to have a publicly available identifier of any smart contract they're going to use to manage or facilitate the DAO. I made a point here to watch for legislative change on this issue because I work very closely with the Secretary of State's office. What we've seen, and again, I'm going to bag on some of the big registered agent companies that mass file entities. What we're seeing right now is the Secretary of State's office doesn't realistically have a way to police the quality of those public identifiers, nor do I think they probably should from a policy perspective. But to the extent we can, we do, like us getting back to that transparency conversation a little bit ago, I think we do want to at least ask people to disclose to their membership through their article filing what the public identifier is. What we're seeing in practice right now is a lot of people just put something like to be determined, in the box and not fulfilling that obligation. So what I think is going to happen, and we'll see, the legislature has to pass it, but is a requirement that if you don't make that publicly available identifier known in the articles within a specified time, probably like 30 days after filing, your filing's void and you have no legal recognition. So I would watch for that, but I mean, good practice tip. We're requiring our clients to make sure they have a public identifier because I just think it's bad practice not to. Yes, sir.
How did you guys balance the privacy concerns with this? I guess the thing I said that this could mean that the kind of like cap table or like the ownership of it is publicly available and like even like maybe like votes and stuff like that. So was that part of the discussion?
Well, not specifically, but I think it's inherent that we're leaving that up to the companies, right? So just because their smart contract, identifier is publicly available, there's still some control on their part as to what's available, right? To whatever's pointed at. So it doesn't mean they have to put their cap table on there. Maybe it does, right? Maybe everybody's got a Ethereum wallet address and it's really easy to tell who's got what. But I think that's still yet to be worked out by these companies. Let's see. Oh, I had this other bullet point again, which I won't go through in detail, but I think this is important to understand because it's a little bit different from the underlying LLC Act, and that is that the articles in the smart contracts for a DAO shall govern all of these things. And this isn't elective, this is a shall. And so again, we're going to talk in a moment about the hierarchy that Wyoming has created, but I think it's important for lawyers and practitioners to understand that where in a traditional LLC, you get away with almost nothing in the articles anymore, and we very rarely include information in the articles, that's not going to fly with the DAO. So here we are to the legal hierarchy. So there's language obviously in the act to create what I call this hierarchy. And so the way that the language of the act currently works is that if you've got smart contract and articles that are in conflict with each other, the smart contract is the predominant document or body. If there's a discrepancy between the articles and the operating agreement, the articles, right, will specify, and then you have the operating agreement. This is, as far as I know, I'm not aware of any other entity structure that has done this and taken a step to define, again, a set of rules or a body of text or code and created it or put it as the preeminent decision maker for the entity. I have down there at the end, sort of, if you've been around the blockchain space at all, you hear the phrase "code is law," and this might actually be the first place I'm aware of where we kind of make code law. And so it really creates, again, an emphasis in my mind. And this again, frankly, was a very deep discussion, I think, by the legislature to understand the implications of this. And one of the reasons that led to the transparency requirements of the articles that, hey, people need to understand what they're getting into here, because I think there was a realization from a policy perspective by the legislature that these smart contracts, I mean, the state doesn't have an ability to police them and know what's in them. Again, that responsibility is going to be on the participants of the entity to make sure that they understand. Yes, sir.
So does that, in essence, at least as to intra-member disputes, crowd out the role of the judiciary?
Great question. I don't think so, right? Because if ultimately there is a dispute and the code can't handle that dispute, right, we might have to go down to the articles. We might have to go down to the operating agreement. But in my mind, it's not still any different than an operating agreement that two members disagree on the interpretation of, right? You still may need an arbiter, a judge, a decision maker to interpret that. God help us when judges start interpreting code, but I think that ship has sailed. Yeah.
Can you talk about how that ties in the conversation with the Chancery Court? Like, what's their original jurisdiction?
Yeah, so the new Chancery Court in the state of Wyoming is going to have, I don't know if we call it original jurisdiction, but direct jurisdiction over business, corporate, shareholder, trust, estate, commercial disputes. We actually had an interesting discussion yesterday on this very, very topic, which we'll get to in a minute. The DAO LLC Act has a unique provision that if certain requirements, or I shouldn't say requirements, if certain conditions ever appear in the DAO, such as there's no longer a human involved or a human behind the DAO, it has to dissolve. It's forced to dissolve by law. Or if the DAO suddenly undertakes an unlawful purpose. And so the question was, who should be that determiner? Right now in the LLC Act, it says the Secretary of State's office. But I think we all recognize that that's a fact-finding issue, and that probably should be a function of the court. So the question came up, should that be exclusive jurisdiction of the Chancery Court, for example? Right now, the act doesn't contemplate the Chancery Court having exclusive jurisdiction, but pretty quickly, some judges are going to have to get up to speed. So I'm going to rifle through a couple of other things. I'm starting to run short on time, but some of what I thought were kind of important provisions to call out in the DAO Act. Obviously, to the extent that the articles or smart contract don't provide, DAOs are authorized to supplement with an operating agreement. The management of the DAO has to be vested in the members. If it's member managed, or if there's a smart contract or algorithmically managed, that's got to specify how the management is going to work. Again, I note here to stay tuned for new language because we're slightly tweaking some of the language involving the management. This has to do with what I mentioned originally with respect to calculation of a majority of the members and how an LLC might go about computing what the majority of the members look like in terms of exercising the management. So this is going to change slightly, but I think the importance is still there that anybody forming a DAO better understand that hierarchy and better understand where the management's going to fall. Because if it's not going to fall in that smart contract, or if that's going to be waived, right, then it's the articles and then it's the operating agreement. Standards of conduct for members. I've had people make comments to me like this is controversial. I don't think it's controversial at all, but obviously no member of a DAO has a fiduciary duty to any other member. That's not really any different from most corporate law now anyways, just by virtue of the fact that you're, a shareholder in a company doesn't mean necessarily that you own a fiduciary obligation to your fellow shareholders. You might, right, in certain contexts. And we obviously preserve the covenant of good faith and fair dealing. Remedies in this context is going to be really interesting to me, as members have disputes and things. Yes, sir.
How about in a situation where one member controls voting, the majority voting? Majority voter may have fiduciary duties to.
You're right. It's could. That's probably going to be fact situation dependent.
That ruled out by virtue of the statute.
Is it ruled out? I don't know that it's ruled out. Again, I would probably argue that that's going to be pretty fact dependent with respect to how they're exercising that vote, how they're exercising that control. What I think is, to me, is interesting in this context, and we've talked about this a little bit in our firm, is I don't know if you're familiar with the concept of direct and derivative claims, where a member of an LLC or a shareholder in a corporation might have belief that the entity is taking action that's not in the best interest of the shareholders or the members, right?
Yeah.
So that member or that shareholder might be able to take an action against the company as a direct or derivative claim, right? To remedy that. And so I think that is called into question here.
For example, that votes put up to the DAO, we should sell all our assets and interests. The majority owner says, I vote sell. He's going to sell to his cousin for not a favorable price. And it was self-dealing. And
I think you've got other claims there, right? In that context against that member. Maybe.
maybe because the as I understand it, the covenant of good faith and fair dealing is much less standard.
Yeah.
And so I guess you have to
Well, I think what you're describing calls into consideration a practical implication, and that's something that we've spent a lot of time talking about with some of the DAOs that we're working with, and that is for a DAO to spin up right now, unless you truly are just community driven and you do this organically and are able to decentralize the control. Most of the DAOs, at least that are taking advantage of something like this LLC structure, it's going to start with a nucleus of people. There has to be a mechanism to transfer that power and that voting concentration from that nucleus of people to a lot of people. And that's something that DAOs are working through, right? Because there's got to be a process to that. There's got to be a timeline to that. There's got to be an understanding of how and when we're truly going to push to decentralize the control. And part of that is what you're talking about, and who's going to maintain that last shred of control before you flip that switch. I don't have that answer, but I think that's definitely an issue for DAOs to consider. Let's see here. Some operational issues that I kind of called out. So the membership interest for member managed DAOs, unless it's otherwise provided for in the articles, the smart contract or the operating agreement. And this is one that is going to be updated with the new language that we have coming. But right now, membership interest, and again, this is the default rule. So if it's not specified otherwise, but the membership interests are calculated by dividing the contribution of digital assets by the total amount. So it's just, a pro rata share of the digital assets. So if you're an ERC based DAO and there's 100 ETH and you contributed 2, you've got 2%. It's that simple. Can that be modified by smart contract operating agreement? Yes, it can, but this is the default rule. Interestingly, and share it with you all, we had quite a debate yesterday in the legislature about whether or not that should be limited to digital assets in the context of the DAO, or should it be broadened to include any type of asset? We didn't contemplate that last year. We contemplated these entities being native to digital assets, but maybe that warrants some discussion. So I don't think we really landed on a decision, did we? Or did we?
Not that area.
Yeah. So either way, I would anticipate some clarification in the Wyoming law on that. And again, I would remind everyone that this is intended to be the default rule, not necessarily, capture the realm of possibility. Yeah.
Doesn't someone having a 51% membership interest kind of make it not decentralized?
Yeah.
At a certain point, is there any kind of consideration of kind of putting in something to end the DAO if someone captures it like that?
So I think what you're getting at is what we were talking about a minute ago, and that is, you could be a manager managed LLC, right, with two members, and one person have a minority interest, but they're designated as the manager. You could have two members of an LLC, and it's a member managed LLC. The key distinction, at least under the LLC Act, is there's different assumptions with respect to the underlying default, right? So under the LLC Act, if you don't specify otherwise, and we have multiple members and it's member managed, everybody gets one vote. So that's kind of the premise that this started from, is that if it's not modified by the smart contract or the operating agreement, there's got to be a default. So here we're saying, look, if digital assets are contributed, we're going to do that on a pro rata basis. And the second bullet point here you'll see is if there's not digital assets contributed or required as a prerequisite, then everybody's going to possess one vote, or one membership interest, however it's denoted, is going to be one vote. Now, again, that could be modified, but that's going to be the default assumption.
My question was should you really allow someone who's running a DAO, who's controlling it, 51% interest, should you really allow them to avail themselves to the statute?
Yeah. Well, that's a great question. I think that gets at the.
Can a DAO exist with a controlling share?
Yeah, that comes down to if somebody forms a DAO and they're just using it as a single member LLC, right? Are they deserving of that protection? Are they really getting that protection?
You hope the market would look at that too.
Sure. Yeah.
Working its way through that situation.
Yeah.
Well, there's also the situation where you start where you have majority share, but that's not the intent. It's to reduce it. But at the same time, when you're in your initial development phase, you have to have control. Otherwise, your intent can be erased.
I'm worried about something like a public good where a big corporation has a lot of shares in it because they have a lot of things they're using on that public good.
Well, I'm
And
also
then-
concerned about another big corporation coming in and buying a big share in order to get controlling interest in order to kill the DAO.
Yeah, it's a challenge. The last bullet point on this slide is I'm going to call it to people's attention because this is a shift from the underlying LLC Act, but it specifically says in the Act right now that members don't have the right to separately inspect or copy the records of a DAO if those records are available on blockchain. All right. So again, the orientation of the statute is towards transparency, public disclosure. So yeah, I'm going to go through these really fast because we've got like 4 minutes left, but the withdrawal of members, I just find this interesting as a practitioner and working through these problems, but a member can only withdraw from a DAO in accordance with the terms set forth in the smart contracts or the operating agreement. So that creates some interesting issues if you're familiar with the concept of dissociation of a member in an LLC and what that means to dissociate. A member of a DAO may not have the organization dissolve for failure to return the member's contribution to capital. Doesn't mean you don't have an action or a legal claim against the DAO, but you can't, on that sole basis, demand the dissolution of a DAO. Again, I think the policy choice of the Wyoming Legislature here was recognition of these DAOs might be hundreds, thousands of members, right? We don't want to get in a context where you have that classic two or three person LLC and somebody can't get their money out, and so they want to sue to dissolve. We're trying to remove or at least limit that remedy. Unless the organization's articles, smart contracts, or operating agreement provide a withdrawn member forfeits all their membership interests in the DAO. Again, same sort of policy here, and that is we're not going to have a lot of control over those people that either choose to dissociate, choose to withdraw. Reinserting themselves into the DAO might be pretty tricky. It might be really tricky for a court to try to chase that down and determine the factual circumstances there. So we drew a line. And then lastly, I'll just touch on this dissolution really quickly. So uniquely, the DAO Act says that a DAO has to be or shall be dissolved upon the occurrence of any of these following. So the fixed period expires of the vote by the majority of the members at the time or upon the occurrence of the events specified in any smart contract. If the DAO has failed to approve any proposals or take any action for a period of 1 year. So again, that was a line in the sand that was drawn by the legislature that they don't want these DAOs becoming dormant and inactive and still trying to claim some type of liability protection. And then by order of the Secretary of State, if the DAO is deemed to no longer perform a lawful purpose. Again, I note here, stay tuned for changes because I'm not throwing shade on our Secretary of State's office. They don't want that duty, and they shouldn't have that duty. That's a fact-finding duty, and it probably properly lies with the court. So I think that we're likely going to change that this next session. What's up next for DAOs? I think I kind of walked through some of the definitional cleanup, the clarification of the member rights, the mandatory dissolution and the court remedies. David, I'm going to call on you. Am I missing any of the big ones? I think those are the big ones. Yeah. But definitely if this is something that you're following closely, continue to do so because there will be some proposed legislation upcoming with updates to this. Like I said, I very candid with people and saying I take no stance that we got it perfectly right on the first attempt. And if any of you are familiar with the legislative process and have been through that process, you know that getting changes and getting the language exactly the way you want it is not always easy. So what we got, we think was a pretty good result. It was a pretty good first stab, but we've got a ways to go. So we'll keep working at it. Yes, sir.
If you guys would be willing to opine, I'm just curious, as the first DAO, as a senior leadership team, how do you all look at like when you flip the switch and hand off control? If you're not comfortable talking about it, I totally understand.
Well, if we really try to build a decentralization and we have to dramatically distribute the tokens. So if you have a mission, you need to look at who are the constituents. You need first identify them and distribute them step by step and make sure they are really contribute the organizations in the futures. So when decentralized organization function, that means the center does not function as a no power. But every individual or every entity inside that community blockchain should be their own leader and also interact with each other. It's a pluralism. So they need to take over the leadership, usually residing in the center. You need to identify that type of structures and make that work. So we are doing that. So our name is American Crypto Fed. We are just fighting with the SEC because if you want decentralized, you must be disclosed and transparent so that all those members, all those people's token holders everywhere need to know the information you need. And no one control where you need information. So fighting with SEC will help us because through that process, we are still distributing our tokens. We are very transparent with SEC. We use the SEC as a great tool for us to discipline ourselves, to make sure we follow the decentralization path.
We haven't even touched the securities issues. That's a full day, CLE right there,
But if I could just add a couple of words on it, I mean, it's really going, and I think Matt would absolutely agree on this, it's going back to the spirit of the law, okay? You want to be a decentralized autonomous organization. You're not looking to shelter and hide, you're looking to create and to get engage as many contributors as possible because you're going to develop synergies as those contributors begin to take up speed. So we're at the phase where we're able to,
One question there. I mean, because for me, the decentralized part was never about the power. Right? It can be. There is a spectrum. You could have a very efficient, super hierarchical, just digital native company that becomes a DAO. I think just decentralized sense that it runs decentralized infrastructure, but it's very clear who gets more profits. Somebody could be the complete owner. I don't know. That scenario doesn't seem to be really considered, right? DAOs are really for decentralizing power.
yeah, and I think maybe I'll just say this in closing because we gotta go for the next one. But I think what you're getting at is sort of that tug and pull between the community, right? The developer community aspect and the use of these DAOs to collectively create and develop and, right, take direction, take action. That's great, but in order to give that project limited liability protection under an existing structure, there's still some trade-offs, right, that have to be made. And I think we don't even know what we don't know yet about where that's going to go and how that's going to develop. But right now, a lot of those developers are screaming out and saying, we have nothing, right? We have a common law partnership. And so this may or may not be a good solution, but it's better than what they've got. So yeah, that's it. Thanks, everybody.